All right, this next book that we're going to get into, which is part of a series of classes that were put together by some learned men that may or may not be part of the legal society. Excuse me. This one is Cause of Action and Civil Defense, roughly about 70 pages long. So every time I do a video, I'll tell you what I'm reading from. That way you know if you're following the right video or not. The last series was all on objections. I can't remember exactly how many videos that were done. However, this course right here is Causes of Action and Civil Defense. And it's basically going to teach you how to structure a lawsuit, bring a claim, bring a counterclaim, and on what grounds, the elements, the defenses, the declaratory judgments, defamation, duress, fraud, goods sold, injunctions, preliminaries, elements and defenses, international infliction of emotional distress, or intentional infliction of emotional distress, otherwise identified as alienation of affection with CPS, you know, them being involved with your offspring. It causes a situation where you're in a peculiar situation where you're being, it's an alienation of affection is what it boils down to. Latches, miscellaneous or malicious prosecution, negligence, quantum merit, and promissory notes is some of the elements and things that we're going to cover in this one. Again, all these books that I have are 70 pages long. They're written in plain English. The words that you don't understand, feel free to go look up. So you do have an understanding. There really is no substitute for reading. And because I'm going to read this stuff anyway, I just go ahead and make videos to help you guys out, to thank you and show appreciation for all the support and love that you give me in my times of need, and supporting what I do in order to be able to do what I do. I extend that gratitude to everybody else. So really, all of this love that's being portrayed here is being generously donated to you by so many countless others that sign up for selfgovernanceU.com that support me being able to do what I'm doing currently. So a big round of applause to all of them. We really appreciate it. And all those who formerly supported me, currently support me on Self-Governance U and through other means and by other ways, through prayer, through gifts, gratuitous gifts and things of that nature. Everything is greatly appreciated. So again, we're going to call this next series of videos is going to be over causes of action and civil defense. So without further ado, let's get started here. Essential elements. Think of a lawsuit like a recipe for baking a pineapple cake. There are certain ingredients you must put in if the cake is to turn out right. If you are trying to make a pineapple cake and don't add any pineapple or pineapple flavoring, you are not going to get a pineapple cake. You might get something else and it might taste yummy, but it won't be pineapple cake unless you add the essential ingredients. The essential ingredients to a lawsuit are called the elements of a cause of action. Every lawsuit must state at least one cause of action, ergo, breach of contract, negligence, fraud, etc. That is recognized by the jurisdiction where it's filed. Each cause of action, in turn, requires certain ingredients to be included in the allegations of fact that purport to state the cause of action. Ingredients we lawyers call the element of that particular cause of action. Each cause of action, like each kind of cake, has different essential elements. That's what this book explains. For example, if you sue or are sued for breach of contract, the complaint must include at least 3 essential ingredients. The element of the cause of action we call breach of contract. If you fail to state all elements, you fail to state the cause of action. Existence of an enforceable contract. 1. Acts of the defendant that constitute his breach of the contract. 2. And damages to the plaintiff resulting from defendant's breach. 3. Failure to include all 3 essential ingredients, elements of cause of action called breach of contract, exposes the complaint to a motion to dismiss. What do we call the motion to dismiss? Why? What do we call the motion to dismiss? Why? It's called a motion to dismiss for failure to state state a cause of action. That's what. I told you this isn't rocket science. Of course, just saying what's stated in the 3 points listed above isn't enough to create an effective winning complaint. You not only need it to state all the essential elements, but you must also state all the ultimate facts that substantiate and corroborate those elements. For example, in stating a cause of action for breach of contract, you should state all the facts that support the elements of the cause of action, as the following example shows. Count 1, breach of contract. 22. This is an action for breach of contract. On April 1st, of this year, the defendant offered to sell plaintiff his famous prize bull for $200. Plaintiff and defendant signed a written contract agreeing to the terms of the bargain, and plaintiff gave defendant $200 in cash. Copy of the written contract is attached as Exhibit 1. Later that same afternoon, while visiting a local tavern where the defendant goes to drink himself silly every day, plaintiff learned that the defendant had been bragging how the bull had died the week before. Plaintiff made demand for the live bull he bargained and paid for. Defendant failed and refused to deliver the bull or return plaintiff's money, thus breaching the written contract between them. Defendant suffered $200 in money damages. Wherefore, plaintiff prays, okay, and the word praise is again P-R-A-Y-S. This is an equitable term. This is an equitable pleading here. When the plaintiff demands or requires, we're looking at more of a military style pleading. But when we're reaching into prayers, P-R-A-Y-E-R-S or praise, we are talking about equitable relief here, okay? So it's really important. I don't know that most lawyers even realize that that's what that means. I've seen it in their motions where they'll say, therefore, the plaintiff requests or demands or requires that this court take said action. And then you'll notice in other motions, they'll say, therefore, the plaintiff prays, and they're changing the jurisdiction of the court with the words. Remember, jurisdiction is the law of the words. Wherefore, plaintiff prays, so he's looking for some equitable relief. The court will award him money damages and such other relief as may be reasonable and just under the circumstances, including plaintiff's reasonable attorney's fees and costs. That's how it's done. See, it's truly easy once you see the common sense of it. All facts are alleged that need to be alleged to set forth all elements of the cause of action for breach of contract, and additional facts are alleged to put the court on notice what the case is about and what the plaintiff intends to prove, i.e., what he needs to prove to win. Of course, there's more to winning lawsuits than knowing the elements of a cause of action. Whether you are the plaintiff bringing the lawsuit or the defendant trying to make it go away, however, it is essential for both parties to know the elements of every cause of action in the case. So when the state's bringing a claim, you're entitled to know the nature and the cause. They'll always tell you the cause. They'll never give you the nature when it's state versus, Derek S. Gonzalez, for example. But when you're bringing a private suit against somebody else, make sure that you explain the nature and the cause, whether they are suing or being sued. This tutorial explains the elements of common causes of action and defense that may be asserted successfully. Whether you are suing someone for damages you say they caused, or being sued for damages they say you caused, it just makes good sense to know the elements of every cause of action, because a case improperly stated cannot be won. The following pages list most common causes of action and some of the defenses that may be raised. The list is in an alphabetical order. If you'd like to see explanations for causes of actions or defense not included, please email the attorney, and we'll try to include additional causes and defenses, future editions of this tutorial. For more information about all our tutorials, please read the back of the book. Learn how to win lawsuits. All right. Abusive process. A cause of action for a tort, which would be a common law tort, which would be a trespass against your unalienable rights or your, there's another name for it, substantive rights, okay? So A cause of action for the tort of abuse of process arises when one intentionally uses the legal system to attain a wrongful result. This is also called baratry, all right? A simulated legal process, fraud upon the court. It's causing you a harm. Remember baratry. It's very important and very rarely do you hear about it, okay? Thus causing another unjust injury. The term process applies to the summons that attaches to a complaint served to initiate a lawsuit. The term may also apply to witness subpoenas or other special orders or writs issued by the court that command persons to do certain things. Okay, so remember, there's a subpoena and then there's subpoena duces tecum, and it's really important that you understand they are two different things. A subpoena is to subpoena a man or woman to come in before the court and testify or provide evidence or information that they may have, being a first-hand, second-hand, or third-hand witness to an event, having perfected knowledge of the situation. And a subpoenas duces tecum is where you're requesting they bring records forward, okay? So just when you subpoena somebody, know that just merely subpoenaing them isn't enough, and when they come to court and they don't have all the documents that you expected them to bring with them, know that you didn't follow a process and now you've created a problem for yourself. So when you subpoena them, also make sure to do a subpoenas duces tecum for them to provide their credentials, bank account records, whatever it involves in your lawsuit. Make sure that all that information is brought forth, okay? It is the abuse of the court's process and injury caused by that abuse that gives rise to this cause of action. The person injured by such abuse has the cause of action and may sue upon it. As stated above, however, the injured person must properly state his cause of action and support it with facts sufficient to win his case. So in other words, when a lawyer is using the court system as a weapon, all right, he's engaged in baratry. A lot of times the Hobbs Act comes to mind, where they're attempting to extort you. And people go, well, Derek, they're not asking for money here. They're asking for a certain action. They're still extorting you your time, your labor, your energy. Okay. It could also be malicious prosecution if in fact you prove that what they're doing is wrong. Recently, I just saw a case where a woman was subpoenaed to appear at a court hearing. There were no pleadings before the court. There were no bill of particulars. There was no motion. There was no affidavits in support under the pains and penalties of perjury. Literally what they did was a simulated legal process, which constitutes a false arrest, a Hobbs Act violation. The woman felt that if she didn't show up at a certain place at a certain time, per this order of the court for a mandatory hearing, that something bad would come of it. And because this lawyer had a duty to know better than to just file for a hearing without any supporting documents as to what the hearing was about, he violated due process of law. He falsely incarcerated the woman. It's considered a false arrest. She's been led to believe that she's got to be at a certain place at a certain time or something bad may happen to her. And because of that, she was at a place that she didn't wish to be at a time that she was instructed to be there, all while the court had no jurisdiction. We shut it down with one piece of fucking paper. And the judge was pissed, and he was scowling at the attorney who had a duty to know better. And he was even more pissed off at that attorney because he put his clerk of the court in hot water because she had a duty to know better than to schedule a hearing without sufficient pleadings, without a bill of particulars, and without a cause of action submitted for the hearing. None of that was done. That's a denial of due process of law, ladies and gentlemen, and they're in big trouble for it. And the judge knows it, okay? So she came back and she was all elated. Oh, the judge, he was so nice to me today. I said, the only reason he's being nice, don't think for a fucking second this guy is your friend, because he is not your fucking friend. And the only reason he was being nice to you is because his fellow bar member, his fellow bar rat, screwed the pooch, got caught by me, and we submitted the proper document that put his clerk in hot water and his bar attorney buddy, and he may be implemented in it later if he doesn't take appropriate actions. Now, in his favor, he did take the appropriate actions and continue the case, because we didn't motion to dismiss. We just went ahead and said, hey, you know what? We're ready for you. Let's do a continuance. We already know what they're planning on sending. Let's just go ahead and do a continuance. And this puts us 3 steps ahead of the game. We've already got the negative averments. We've already got the affidavits. We've already got the subpoenas. We've already got the subpoenas ducis tecum. We were anticipating this action being brought, and we are well prepared for it at this point, okay? So those are some of the key steps to really learning this, is to be able to do preventative maintenance. So many people want to be reactive, but in all actuality, you should always be thinking about being proactive and engaging in preventative maintenance. Just like changing the oil in your engine, checking the air pressure in your tires, rotating your tires. That's all preventative maintenance stuff. We don't change the oil in our automobile after the engine seizes. That would be kind of redundant and ridiculous, right? We change it before that happens. It's called preventative maintenance. So I'm glad that you guys are all here, because what we are doing is preventative maintenance. We're giving you the information, so if something should arise, you'll have the capability to be able to assert yourself properly and get some results. For example, suppose Smith sues Jones for fraud just to keep Jones from closing a deal with Miller. Smith thinks when Miller sees Jones has been sued for fraud, he'll doubt Jones's honesty and refuse to go forward with the deal. Smith wants to stop the deal, so he abuses the legal process to attain a wrongful result. In this case, an unrelated purpose. In order for Jones to sue Smith for abuse of process, however, Jones must show that Smith intentionally used the legal system, simulated a legal process, to attain a wrongful result, baratry. If Jones was, in fact, guilty of fraud, the Jones cannot sue Smith for abuse of process, because Smith had a legitimate right to sue Jones in the first place. The underlying wrong that gives rise to the cause of action is provisions of our legal system for an improper purpose, i.e., a purpose the law never intended. If Smith had a legitimate purpose for suing Jones for fraud, there is no prevention, and Jones has no cause of action for abuse of process. Abuse of process may arise where a person either sues another in civil court or applies to the criminal system to achieve an improper purpose the law does not intend. If it may not be necessary for Jones to win the underlying lawsuit brought by Smith, provided he can show in his action against Smith for damages arising from Smith's abuse of process that Smith intentionally proceeded against him for an improper purpose. The maliciousness or lack of foundation of the action itself is irrelevant. It is the improper purpose that gives rise to the cause of action, a purpose not intended by law, and ulterior purpose for which our laws were not designed, a purpose that abuses the system itself. Elements. For a plaintiff to adequately plead a cause of action for abuse of process, he must allege ultimate facts sufficient to establish the following elements. 1. Defendant illegally or improperly perverted the legal system against the plaintiff. 2. Defendant had ulterior motives or purpose exercising such perverted use of the system. And 3. Plaintiff suffered damages as a direct result. Each of these three elements must be explained with actual facts to fully explain how the elements exist in the situation. And to win the case, plaintiff must prove each and every essential fact necessary to allege all the elements. Defense. Absolute immunity. So long as the acts of the court or a judge has some relation to the proceedings, the court system and the judge are protected by absolute immunity from suit for abuse of process. Statements amounting to perjury, libel, slander, and defamation do not give rise to an action for abuse of process. Let's talk about 11th Amendment immunity here just a little bit. That presupposes that nobody's above the law, all right? All men are responsible for knowing the contracts they enter into, thus nobody can claim ignorance of the law and get away with it, okay? So when they're saying that these judges and these prosecutors have 11th Amendment immunity, I'm going to tell you right now, they don't. How do we prove that? Okay, and this is very important. We need to go back and look at was it the Clearfield Doctrine? The Clearfield Doctrine, okay, where it states that when the government engages in business, it demotes itself to that of a mere person or individual and can sue and be sued. Everybody after 1933 is engaged in commercial activity. All branches of government. In fact, if you get a hold of the FBI and you ask them for their commercial charter authorized by Congress, they don't have one, ladies and gentlemen. They're nothing more than a business. Period. All right. And they don't have a corporate charter where they can put onto the record before a court and say, Congress authorized us. Here's our corporate charter. We owe our allegiance to the United States of America's Constitution and all 50 states' constitutions. And we stay within those confines of our commercial charter. Remember, that's the only way they can get a charter. Every police station, every police charter and every private municipality, all of them have a corporate charter, okay? And they're all to be within the guidelines and the bounds of the Constitution, not only for the state that they're in, but also for the United States of America. And when they're outside of that scope of authority, ladies and gentlemen, you can absolutely nail their nuts to the wall. You can absolutely collapse their corporate charter, force them to go into involuntary bankruptcy, and you can take everything they thought they owned, including flak jackets, police cars. And if you think I'm full of shit, there's a couple of us out here that are doing these things, all right? And it's not to say that, people go, oh, well, you're damaging the police force that's put in place to protect us. Look, it is very, very clear. They are not here to protect you. They're here to engage in commerce, to enforce the internal revenue codes, to generate revenue for their principal. And I sum it up with this. It's basically taxation without representation, because nobody should be in a court absent a victim. Absent a victim, there is no crime. The state cannot be an injured party, period. End of fucking story, okay? So, the hope that keeps me grounded. Very well, Heidi. So anyway, again, our actions aren't malicious. They're rather to bring back justice and to make these people, act honorably, okay? Because they're all acting at this point. None of them actually are agents for the United States government as you've been taught in grade school or high school. They're not. They work for corporations. Their corporate charters are bound to the constitutions, and if they fall outside the parameter and the scope of those constitutions by their actions, they are 100% liable for that, all right? Let's move forward. Act after process issues. Before the cause of action of abuse of process can arise, the court must issue some form of process, usually the summons that commands a civil defendant to appear in court and answer the complaint the summons is attached to when served on the defendant, and the process must be used for the improper purpose. No act occurring prior to issuance of the court's process can give rise to the cause of action, intended purpose. There is no cause of action for abuse of process unless the process was used for a purpose other than that for which the law intended it. If the process is used to accomplish a proper result, ergo, bringing a civil defendant before a court to answer a complaint that is itself predicated on legitimate causes of action, there is no abuse of process. We're talking about due process of law, ladies and gentlemen. Even if the process furthers another purpose separate from its legitimate purpose. If a person sued for abuse of process had a legitimate purpose for the process that caused damage to the other unrelated to the legitimate purpose, the cause of action does not arise. There is no abuse of process if process is used to accomplish a legitimate result, even if there is a separate wrongful motive behind it. In most cases, abuse of process arises from some form of extortion, the Hobbs Act, ladies and gentlemen, i.e., it is used to compel another to do something he would not otherwise be lawfully compelled to do. This would also constitute a false arrest. If the one using the process has a legitimate reason to do so, however, there is no abuse and the cause of action must be dismissed. Counterclaim. In jurisdictions where the complaining party need not prevail in the underlying action as a prerequisite to bringing this cause of action, one may file a counterclaim seeking damages for abuse of process. Unless the counterclaim itself stands on a solid footing, however, i.e., unless the counterclaim is justified by the fact rather than being a retaliatory tactic without merit in its own right, the party filing the counterclaim may be charged with abusing process. Check local rules and case law to determine if abuse of process requires as one of its essential elements a termination of the action in favor of the person against which the allegedly abusive process was issued in the first place. When we come back, we're going to talk about accord and satisfaction. And again, we just started this course, and this course deals with causes of action and civil defense.